Hi, everyone, and welcome. Hopefully, this is going to be helpful for those of you who are interested in starting a student loan practice at a legal aid organization. And thank you again for joining us. And please feel free to ask questions, just as Kaja said, put them in the chat, and we'll be able to answer those as we go. So here's a list of what we'll cover today. Just a brief summary of what's going on in the student loan world, and why it's important for legal aids to get involved in student loan work, what a typical student loan case involves, some model legal aid programs that are helping student loan borrowers, resources to help support those of you who are starting to work on this, and tips for how to get started. So here's a first question, true or false? The government can take Social Security benefits to collect on defaulted student loan debt. And I'm a little technically challenged, so I don't know how to so this is just doing it in your own heads because I don't know how to do a poll. Okay, so the answer is true. The government can seize, oops, sorry guys. There we go. Okay. The government can seize tax refunds, including refunds based on the earned income tax credit, garnish wages, and take a portion of Social Security retirement and SSDI benefits to collect on defaulted federal loans. There is no statute of limitation for federal loans, and they can do it without a lawsuit. So this is why, a big reason why it's really important for legal aids to get involved. So, talking about legal aid's role in the student loan crisis, to give you a sense of what's going on, right now there are 45 million Americans who have over $1.7 trillion in student debts. But there are very few student loan advocates and experts available to help borrowers. Um, and this is a real problem for a lot of people because the student loan system has got incredibly complex and difficult to navigate for people on their own. And that's why legal aid advocates can play in a very important role in helping navigate repayment, managing, and eliminating their debts in some occasions. So currently, there are more than 3.6 million new student loan borrowers who have fallen into default post-COVID moratorium. So that's post September of 2023, and the defaults are escalating very quickly. Protect Borrowers estimates that there is a new default every 9 seconds. The total people in default is more than 9 million nationwide. In California, just as an example, there are about 800,000 borrowers in default, 325,000 of which are new, and that amounts to $19.5 billion total, which is huge, a huge issue. And this is from Protect Borrowers. So if you are from other states and are interested in information, you can check on Protect Borrowers' website and see their study and breakdown for all the different states. So the consequences of default on federal student loans, as I said, there's no statute of limitations. These follow people to the grave, and then they can get a death discharge, but that's not much help for most people. Without a judgment, the department can garnish wages, seize income tax refunds, and offset Social Security, disability, and Social Security retirement benefits, which of course impacts a lot of legal aid clients. Of course, it also impacts their credit history, and it makes people ineligible for federal financial aid, so they cannot go back to school or complete their higher education if this is the case. So there's a lot of different issues that come up in student loan cases that legal aids can help borrowers with. The first is sort of whenever you get a case, you want to look at the maximum level of relief you can get for your clients. So one of the first things you can do is help student loans, help borrowers get forgiveness, cancellation, or discharge. And that's by helping them submit an application. Legal aids can really help by obtaining the documents and information needed. Many types of applications require submission of supporting documentation, and then the legal aids can either prepare and submit the applications on a borrower's behalf or provide pro se assistance in some cases. Another useful assistance is helping clients enroll in affordable income-driven repayment plans based on their income. Um, a third way is getting the borrower out of default and stopping collections on federal student loans. So there are ways you can help a borrower out of default, which typically involves consolidation or rehabilitation if they're not otherwise eligible for some kind of discharge, and then helping them enroll in a future payment plan, usually again an income-driven repayment plan to make sure they don't redefault in the future. And then, of course, helping them stop involuntary collection of their tax refunds, their Social Security retirement or SSDI benefits, and wage garnishment. And those that tends to be a bit more complicated and really does require some legal assistance. For the time being, just so everyone knows, the Department of Education has not started SSDA or Social Security retirement or wage garnishment offsets. They are the guarantee agencies who hold the older kinds of loans are doing some of this. But for the most part, the department has not yet started that. It has, of course, started taking tax refunds. Um, and then, of course, what you can also help with is helping them navigate pro se through issues and barriers. This can involve filing a complaint with their congressperson, or sending a demand letter, depending on your state laws, to loan servicers for violations that are going on. So there's a lot you can really do in these cases. Other kinds of cases you may see in various states are the collection of unpaid tuition debt by either public, nonprofit, and as well as for-profit schools. And sometimes in some states, it includes the illegal withholding of transcripts for unpaid debt. So this is when a student is unable to complete or even completes their education, but they still own some tuition to the school. And many schools will withhold transcripts, which means students can't get jobs or continue their education. This is illegal in some states, including in California. So you can really help in those cases. And then, of course, private student loan collection. So a lot more students these days have private student loans, which are not eligible for income-driven repayment and other types of benefits available on the the federal loans. These tend to be very large amounts, and if a default judgment is entered against a person, they can be literally looking at a lifetime of wage garnishment because the debts are so high. I have clients that have been sued on $50,000 loans, have been sued in six different lawsuits at the same time, seeking $200,000. So these are really can be very serious cases for folks if they are not judgment proof. So you can help them obtain information and assert defenses and state law violations pre-litigation. And you can also help by defending these collection actions and bringing cross claims for violations. I'm going to stop for a second. Does anyone have questions so far? I don't see any. Okay, so we'll keep going. So I'm sure a lot of you have seen a lot of stuff in the news about the Department of Education's collection of loans and changes that have been going on, both in the department itself, including massive firings of workers, um, and of course, changes to the law by Congress, including through the One Big Beautiful Bill, which has really impacted a lot of borrowers and made the system way more complicated. Um, as a result of a lot of these changes, um, it's been really chaotic and very difficult for borrowers, I'm sorry, to understand what their options are, and also difficulty in accessing things because there are so many problems with the loan servicers and with some of the systems that the department has. And so sometimes they really just need help sort of navigating these systems and forcing the department to actually properly implement their applications. Um, can the Department of, I'm going to stop real quick because I see a great question. Someone's asking it, can the Department of Education garnish bank accounts? The answer is they can't do so pre judgment. So if they don't have a judgment against the borrower, they can only administratively garnish wages. take some Social Security benefits, and take the tax refund. They cannot take anything from the bank accounts. However, some borrowers do have judgments, federal court judgments against them, sometimes state court judgments. And if that is the case, then yes, the department can garnish bank accounts, of course, subject to the exemptions both in federal and state law sometimes, as well as some protections for bank accounts when borrowers have their Social Security benefits electronically deposited. But yes, that can be an issue, but again, only if the borrower has a judgment against them. All right. So because it's such a chaotic time, again, really critically important time for legal aids to start getting involved in these cases. In addition, because things are just so confusing, and the system is such a huge bureaucratic mess, there is a lot of misinformation that we see quite frequently on social media. And then we get calls from borrowers who say, I want, I heard there's a loan forgiveness program under that Biden implemented and that I should have had all my loans discharged. Well, we have to tell them, no, there's no longer a forgiveness program that was struck down by the Supreme Court. But we do see a huge amount of continuing misinformation on the internet. In addition, there are continuing scammers out there. We call these debt relief scams. I'm sure many of you who do consumer law have seen these in other contexts where these debt relief scammers send out massive emails and or make phone calls and tell people they can get their debts forgiven if they just make them a monthly payment or an upfront payment of money. Then what happens is, first of all, it's illegal in most cases to require an upfront payment for these kinds of services. And in addition, what usually happens in these cases is these scammers either don't do anything or they consolidate people's loans. And consolidation at this point can be extremely harmful to people because of some of the new laws. So if you see this, of course, people can report the scams to their state attorneys general. If they have a Department of Consumer Protection and Financial Innovation or a similar state agency, and other states do have these, they can report them. And of course, to the CFPB, even though the CFPB isn't all that functional right now, it is important to continue to make complaints. And there are options for people for dealing with those contracts. So I wanted to highlight some of the current and ongoing issues that we are currently seeing so you can get an idea of what you'd be dealing with and why this is so important right now. For one of the biggest issues we're seeing with legal aid clients, many of our clients are eligible for what's called a total and permanent disability discharge. These are clients that are often receiving SSDI benefits or Social Security retirement benefits. Note that the department cannot take any SSI benefits. Those are exempt from offset. We also have clients who are not receiving those benefits but are still disabled. And if their doctor will certify that they meet the department's disability standard, they can also get a discharge. There are also benefits based on Veterans Administration determinations of discharge. However, because the department has switched its third-party contractors that handle these discharge applications and implemented a new online system, there have been a huge number of problems in these cases. And so we're actually about to file a lawsuit challenging some of these practices, but more than ever, the disabled borrowers need help applying for and getting these permanent disability discharges. We are, as I said, seeing complex issues and operational barriers to people getting out of default. So people who are in default can usually consolidate or rehab, but we're seeing problems with people even accessing those programs. Many of you, I'm sure, have public service loan forgiveness, so you will know about the SAVE plan. The SAVE plan was a plan implemented by prior administrations, and it had the most affordable repayment plan. It has been challenged in a lawsuit, and the current administration is working out a settlement in that lawsuit, but essentially the SAVE plan is going away. It will no longer be available to people in the future. We expect that settlement to to be finally approved any day. And once that happens, the department will have to move people from the SAVE plan into other payment plans. If they move them, they may move them right into a standard repayment plan, which is the most expensive payment plan. And if people don't make payments under that and don't apply for an IDR plan, they can go into default, which, as you see, has terrible consequences. So that's something that's coming down the pike very quickly. Um, we are going to see barriers also to obtaining IDR plans under the new, what's called the repayment assistance program, which is the new um, income-driven repayment plan for post July 1, 2026 loans. Because that is such a complex repayment plan and has some very difficult calculations, we're very concerned that there's going to be some problems with the implementation of this new plan. Um, Something also to flag for everyone is if you have any clients with a Parent Plus loan that has not yet been consolidated, they absolutely have to consolidate into a direct consolidation loan by July 1st of 2026, or they will lose access to any income-driven repayment plan. They will only be stuck with the standard plan, and a lot of Parent Plus borrowers who seek help from legal aids can't afford their standard monthly payment plans. Um, People notably have to have their consolidation loans dispersed by July 1. So that means they really have to get their applications in. We are saying by the end of April to make sure that happens. So if you have any Parent Plus borrowers, this is a really critical time for them. Um, we're seeing, of course, continuing misconduct by for-profit colleges who target and disproportionately impact low-income people and people of color. And they're expanding their practices into online education. So there will continue to be a need for helping people seek closed school discharges, all the different kinds of discharges available for misconduct by the schools. And finally, we're seeing a lot more private student loan collection lawsuits. And there are numerous defenses people have to these kinds of lawsuits in many cases. So important really to also take a look at these and help people defend them if you can. The other issue, of course, is because of the new laws and issues, um, it's really hard to advise borrowers, and you have to be very careful in making sure that what you're advising them to do is going to be beneficial to them. For example, consolidations, as I mentioned right now, are very tricky. If people consolidate their loans, and they don't do it for public service loan forgiveness, they can lose all prior credits they've earned towards income-driven repayment plan forgiveness, and they start from zero. So that means if people have made income-driven repayment plans or have credits as if they did towards their eventual 20 or 25-year loan forgiveness, if they consolidate, they will lose that. So if they've made 10 years worth of IBR payments in the past and they consolidate now, they will start at zero and they will now have another 25 years to consolidate. So that's a really huge barrier to some people in getting out of default. But that's just an example of what can happen if people are not aware of what their rights are and don't take a very careful look at their student loan data. Um, in addition, as I said before, because there's so many operational problems, part of our jobs now is just trying to resolve issues that are coming up for people in cases that should be fairly simple. And often now involves filing complaints with their Congress people because we no longer have a helpful student loan ombudsman in the Department of Education. We have to sort of find other ways to get resolutions. And really, the primary way now is through members of Congress, unfortunately, but they can be very helpful. So now, this all sounds like a lot. I know it must be very worrisome to many of you who are new to this to hear about how complex this is, but we have a lot of resources at NCLC to help you navigate these complexities. So we're here to help. First of all, if you're going to get into student loan law, I highly recommend that you pay for access to the student loan law manual You can get it online, and there is a 50% discount for legal aids. This is really, really essential. Whenever I get a new kind of case that I've never done before, of course, this was a long time ago, that's my first go-to is learn about, what it is I'm trying to do, read the student loan law manual, and figure out what it is I need to do to prepare a case. And this is an excellent resource for folks. In addition, some other resources for you. We hold monthly meetings for legal aid advocates throughout the country, and we provide trainings on some issue for every one of those trainings. Plus, we also handle updates and let the legal aid folks know what's the latest news, what they need to be aware of. And then, of course, we're available during those meetings as well for any questions folks have about cases they're working on. It's really helpful, I think, for all the legal aid advocates to hear questions from others because they can also learn from that. Um, and if you want to attend these meetings, you can email me, but you also have to first sign up for our legal aid student loan listserv at nclc.org listservs. Once you do that, we can invite you to the meetings. The meetings are held over Zoom on the third Tuesday of the month from 1 p.m. Eastern Standard Time to 2:30. I think that time may be changing. I'm not yet sure, but I'll let you. But if you get involved, we will for sure let you know. And I also wanted to let you know that those of you who are in California, we have a very strong student loan legal aid community, and we have available mentors in California. So if you are interested, I highly recommend you join our NCLC Student Loan Listserv. It's a great place to keep tabs on what's going on in other people's cases and for you to post questions as well. And this is where you can sign up. In addition, we have a lot of information on our Student Loan Borrower Assistance website. This website is really um, structured to be available as a resource for borrowers, but I think it's very helpful as well for attorneys. You can read the latest student loan news there. You can sign up for our blogs where we post sort of updates. You can find answers to a lot of the common questions and links to various types of most up-to-date applications, closed school discharge, TPD discharge, all the different kinds of applications. We have a lot of help videos as well, and trainings. And finally, we are always happy for people to share stories with us about what they see going on, because we do try to contact the department when we can, when we see systemic issues. So it's useful to get those kinds of stories. And like I said, you can subscribe to our blog to get the updates on recent student loan news. We also have a student loan toolkit. So this is a toolkit that is a guide for advocates and borrowers, and it includes all kinds of checklists and fillable pages that you can use to both help you figure out how to evaluate a case, collect information, and then prepare applications and help borrowers with whatever issues they're facing. And this is, of course, free and available to anyone. This is an example sort of what some of the pages look like in our stool kit. So you can see very sort of straightforwardly written as much as we can. And we have quite a few checklists that can be very helpful in assessing a case and options. I also want to mention a couple of statewide models. So in California, our legislature funded a 2-year student loan empowerment network where we provide free services. It's a combination of financial consulting nonprofit organizations and legal aids that we work together to provide free assistance to student loan borrowers in California. NCLC has been the lead trainer for the network, and advocates across the state, we meet on a monthly basis as well to share case issues and updates. The funding is running out for this project in 2026, but we are working on trying to get extended funding. But it's a great example of what can be done in different states if the state is willing and the legislature or governor is willing to fund it. There's a similar project in New York called EdCap. It has been going on a lot longer than the California program. Similarly, it's run by a groups of financial aid, of legal aid counselors and financial counselors, and it's helped really thousands and thousands of borrowers. So these are both models that if you have any interest from anyone in your states, we'd be happy, of course, to share information about how to expand these kinds of networks and get funding for legal services. So other resources. So we have a ton of sample letters and pleadings, including California specific examples in the NCLC manual. So it comes, you can access a lot of these through if you subscribe to the student loan law manual. Also, if something's missing, we're available, of course, to give you whatever we have. Um, Also, the Legal Aid Foundation of Los Angeles, we have a sample intake questionnaire that we use to help us identify when we do an intake what the borrower's potential options are. We have adapted this so that it is now also being used in our student loan empowerment network by both financial consulting organizations and the legal aids. And I'm happy to provide that to anyone who wants to include that. Or use that possibly in developing their legal aid practice. We typically, have one person that does the regular intake, so to make sure that they are eligible for legal aid, and then we have a specialized person who does the sort of intake questionnaire for us because she kind of has a little bit more knowledge of federal loans, but that really helps us to identify sort of what issues may be problems for a client. Like I said, we have many hours of training of videos for student loan issues. And again, if you're in California, we have a strong California legal aid community, student loan community. We do have a nationwide one as well. And we have lists of advocates in various states that are already doing this kind of work. So again, if you need mentorship or help, we can either help you or identify someone in your state who probably can. So again, I will stop right here and see if anyone has questions. Okay, so where do you house student loan attorneys? So I wanted to present this because there's a couple models. I think people who do student loan cases are typically in what is the consumer loan law section of a legal aid, but at where I work, we're actually sort of grouped in an economic stability unit with the public benefits lawyers. And I find this really helpful because the vast majority of the work that you will do as a student loan attorney is administrative law before the Department of Education. And so we actually have a lot in common with the public benefits folks, especially because also we have many acronyms and crazy bureaucratic programs. So think about, if you want to start a practice, do you put it in the consumer law section or maybe you put it in your public benefits section because it is an economic stability issue for a lot of our clients. Um, I would say start simple. Start out, for example, you can start with only certain types of cases. One example would be to only help assist disabled borrowers getting TPD discharges or with their student loan repayment if they're not eligible. That would be one way to really start getting your feet wet, is to focus on sort of some of the populations that are most in need and should have fairly straightforward cases. And then you can expand slowly into higher priority cases. For example, maybe you start helping borrowers who are in default on their federal loans only. That's another option. Um, and then one thing I recommend is just, yes, we have videos and training materials, but ultimately the way to learn is by doing the cases. And that means just digging in and getting the NCLC manual and figuring out how you proceed with a case, and of course, reaching out for help when you need it. One thing I will mention is it's not always easy to know or identify these borrowers, right? Because one of the things you have to do when you start a federal student loan case is you have to get their data first and you have to review their student loan data so that you can figure out their options. So you do have to put some time into almost every person that calls. But it's worth doing that and learning the student loan system so you're giving them accurate advice. So as I said before, what we do is we have a basic eligibility intake, which is through our general intake line or our online intake. And then we have a specialized person call the person back, make an appointment to both get more information from them about what their student loan situation is and to help them in some cases download and provide us their federal student loan data. All borrowers have access, and I'm sure some of you have accessed it to their federal student loan data. There's a specific data file that they can download from the department's website that we need to see. And so we usually have an email we send out to them explaining how to do this. And some borrowers are able to download it and send it to us. Others need help. And so this person, our student loan intake advocate at Legal Aid, will help them to do that. And then once they do, they pass the case on to the attorney for review. So the specialized student loan intake, as I said, is you fill out a very short student loan questionnaire, and then again, help the borrower download the federal student loan data. We also have the data is kind of, I don't know if any of you have seen it, but it's a single spaced multi-document document, multi-pages that is, it looks like gobbledygook. It's not easy to read. We have an actual, my colleague Milo has prepared or developed a program that you can run on the text file, and it will actually prepare an Excel spreadsheet for you that's really easy to read. And so if any of you are interested in that, that's something we can also provide you with, which can be a big help. But we also have a training video on how to read the text file if you want to do that as well. So for legal aid, obviously there are different levels of service that you can provide. You can, after you review the student loan data or the private loan documentation, again, if there's a private loan, you will have to get documentation to figure out what their options are because for private loans, the terms of the contract and state law will govern what a borrower's options are. So you do have to get the promissory note and get the payment history. So that will take a little more time to figure out. And again, we have letters and samples about how to get that documentation. Um, so you can do everything from providing counsel and advice on explaining to borrowers, for example, how do you apply for an income-driven repayment plan? How do you apply for a consolidation loan? And giving them instructions on how to do that on their own. Quite a few borrowers are able to do this on their own. Of course, we have clients that can't or that hit barriers, but a lot of people can do this on their own. And then, of course, you can provide a higher service, right? So help them rehabilitate their loans to get out of default, help them submit a TPD, a total and permanent discharge application, um, or a closed school application, represent them in a private student loan collection case, or pre-litigation, you can write a demand letter under the applicable state laws if you have a debt collection law. Some states also have specific private student loan collection laws that are very helpful. So these are sort of all different levels of service that you can choose to provide. Um, and then find funding. Well, funding is very hard to find. I'm sure many of you know. That's why our Student Loan Empowerment Network in California is so great because it actually provided funding to hire for many legal aids. I think there are 7 of them in California that have been able to hire full-time attorneys to focus on student loans, or they can fund people part-time if they are also doing other kinds of work. So again, something to think about, seeing if you have a state legislator or a governor that might be willing to fund something like this. Of course, another source is law graduate fellowships. If you have a great summer law student that you really like and they can, propose a 2-year, 1-year or 2-year fellowship, that's another great way to get started. I don't know of other funding. As you all know, it's really hard to get direct services funding from foundations. But I think, it's definitely important to keep your eyes open because, debt collection on student loans is in the news almost every day. So there may be funding opportunities out there. But I wish I had better news because I know we're all struggling with our, keeping going in these difficult times, but good to keep an eye out. So, some other things that you may or may not be interested in. If you do get involved in student loan work, there are opportunities to do more impact related work. So what we do at Legal Aid, and I'm sure all of you do this at your legal aids, is keep an eye out on what's going on a systemic basis. So if you start to see a lot of clients who are having a particular issue, that could indicate there's a systemic issue. For example, we've been seeing, again, as I said, a lot of problems with disability discharges. And once we started seeing a lot of those, we knew there was a systemic issue. And so there are ways you can work different ways to address those. Of course, one is policy, working on federal policy under the Department of Education, and whenever the regulations are updated or changed, the department has to go what's called a negotiated rulemaking, which involves basically through the Federal Register inviting different stakeholders to submit nominations of people to represent them. Legal aid is specifically named in the statute as one of the stakeholders for negotiated rulemaking. And so we are often asked to nominate people to represent us. And then those legal aid attorneys actually represent us in the negotiation, which is in person. During COVID, it was online, but now it's in person. And we're specifically allowed to do that in the federal regulations as long as, of course, we don't use LSC funding. You can also participate in drafting comments to the federal proposed regulations or submitting written comments or signing on to comments on your own. And then, of course, there are often opportunities on the state level as well to work both on private student loan issues and for-profit oversight issues, both legislative and regulatory. So if you're interested in looking for impact opportunities on the policy level, there are definitely those opportunities. Litigation. You can also have litigation opportunities through the Administrative Procedures Act. So, for example, we're about to file a lawsuit challenging the department's new uh, discharge pol disability discharge policies. And that includes alleging we believe that there are policies they've implemented that are violations of the Higher Education Act. And so we're filing those as Administrative Procedures Act claims. Um, so that's something you can do. And then, of course, litigation against other entities for violations of consumer protection laws. In California, we have quite a few that we can use, but every state's different. But there's also opportunities for affirmative litigation. And finally, working again in coalition is really something you can do that's helpful. For example, we recently wrote a letter about total and permanent disability discharge issues to the Department of Education, asking them to address those practices and including examples of actual legal aid clients that we are seeing, the kinds of practices we are seeing and pushing for change. Of course, they ignored our letter, so it wasn't great. But we continue to try to find sort of more less formal solutions, more informal solutions, letter writing, contacting lawmakers about specific client issues and seeing if they will approach the department about them and things like that. So keep that in mind, including if you have potential fellows, those are also areas that they can pitch working in. So the big takeaways for today are that, before you advise a borrower, make sure you review their federal data, super important. Um, but we are here to help you so you don't have to start from scratch. The manual is great, and we have lots of resources to assist you with getting started. Um, I just want to say, I know again, sounds so complicated, but really it's so important. And it is something I think everyone can do. There is a learning curve, but you just got to take it step by step. And then, of course, reach out to us, join the listserv. We're all here to help get you started. Does anyone have questions? Okay, so I'm seeing a question from Heather. For student loan borrowers on the SAVE plan who would like to get on another IDR plan due to PSLF, what IDR plans are currently available to move to? Great question. So, of course, it depends. This is why you have to look at the data. It depends on what types of federal student loans they have. If they have all the borrowers now have student loans that were made before July 1st of 2026. So those borrowers are generally going to be eligible either for an income-based repayment plan or an income contingent repayment plan. We cover both of these in the manual so you can see exactly how they are calculated. You can also see them online on the Student Borrower Assistance website. And EdCap has a very good program so that you can actually calculate the different potential payment plans you would have under each. IBR is the better payment plan available. The pay plan, which was another available plan, is going to go away. So I just say get the IBR plan to people at this point. Now, something to note is that if any borrower gets a loan after July 1 of 2026, gets a new loan, in most circumstances, they are no longer going to have access to the IBR or the ICR plan. They will have to use what's called the new RAP plan, which is completely different in how it's calculated. It actually can be much more affordable for some borrowers, but also problematic and more difficult to pay for others. For example, the new RAP plan has a minimum payment of $10 a month, whereas the IDR plans currently available, you can get a $0 monthly payment plan. For legal aid clients, this can be very difficult. I have clients who are living on $221 a month in general relief, and that is it. If they have to pay $10 out of that $220 a month, I mean, that's a real hardship for them. It's impossible to even live on that amount. So there are going to be some real issues, I think, for low income people under the RAP plan who are new borrowers and take out loans after July 1 of 2026. For PSLF, that will be your option. So you will have the RAP plan if you take out new loans after July 1, 2026, RAP will be a plan for you. RAP will be an option. So you may find that RAP is a better plan for you, and you can opt under PSLF after July 1st to choose RAP instead of IBR or ICR, but those will also be available to you. This is so complicated, so hopefully you all understood what I just said. But if not, this is all explained on both the Student Borrower Assistance website and in the manual. Does anyone else have questions? The other thing to note is if you have a borrower who has to consolidate FFEL loans, so FFEL loans are the old kinds of loans, and they're not eligible for public service loan forgiveness. If they have to consolidate to be eligible for public loan service forgiveness, they will not lose the prior IBR credits that they earned if they consolidate. That's the only situation where they won't lose those prior credits. So. Okay, so what if you don't have new loans from 2026? Can you still move to RAP? Yes, that's what I was saying. So you can choose IBR or ICR right now, but after July 1 of 2026, theoretically, you should be able to use RAP as well. Please note the department will see how quickly they can implement the new RAP program. I don't know how quick it will be, especially because right now they're promulgating the final regs. The proposed regs for RAP are out for comment right now, so they don't even have any final regs yet. And knowing the department, I think it's going to take time for them to implement the new RAP plan. And I don't know what they will do in the period when people can't get RAP after July 1st. You may be able to get a forbearance while you're waiting. I don't know what's going to happen, but just to flag that it's probably going to take some time. Does anyone